Hi, welcome to the It's Your Money and It's Your Estate Spring 2025 workshop series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Now, let's start the program. This webinar is the 6th and final session of the It's Your Estate workshop series. The topic of the day is estate administration. Our moderator is Peter Kote, and our guest speaker is Trevor Murphy. Enjoy the workshop.
There we go. All right. Mr. Trevor Murphy, you are a professional licensed fiduciary in the state of California. So let's first introduce you formally by going through your education. What is your education level?
I have a master's degree from Georgetown University in foreign service. So diplomacy, international affairs, those sorts of things. And then I have a bachelor's in economics from UC Berkeley.
Two good backgrounds for being a fiduciary, because being a diplomat is very much needed when you're dealing with a family.
Yes, yeah, we'll go over that today, but there's always family dynamics, and remaining impartial is one of the biggest skills that you could have as a professional fiduciary.
Yeah. There really isn't any credentials in the fiduciary world per se, although your MBA or your your bachelor's in economics certainly does help. But how many years of relevant experience do you
Yeah.
have?
Sorry, I left that blank. I have 12 years now, which seems I was counting that the other day, and it's hard to believe it. Time flies by.
Yeah.
But I've 12 years, and in this particular field, um, it takes some time, a few years for your practice to ramp up, because you have to get the trust of people that, attorneys, financial advisors, CPAs, that to trust you enough to refer clientele to you. It's a little different than a lot of fields where we don't put documents in front of clients and have them sign it. We everything comes through referral, so it takes a while to build your network.
Yeah.
But
So
then
you have,
yeah, but then
so you have to have a license to serve as a professional. Um, what is that about?
well, the the Professional Fiduciary Bureau was established under the Department of Consumer Affairs in 2007. So it's not that old. About 18 years ago, they started issuing licenses to do this work. And you have to have, if you have two or more cases that are not family, then you have to get a license to serve as an individual in the fiduciary capacities. California, our state, is on the vanguard of the licensing of private professional fiduciaries. We've done it longer. We're the only state that actually has a bureau specifically there in our state government to basically govern our profession and act as a recourse for, let's say, consumer complaints and so forth.
Can you
Uh,
pull up Trevor? Can you pull up that website?
I sure can. Oh, that's
I
right.
think it's important to check out everybody,
Can you see that?
whether you're a financial advisor, to go to broker check. If you've
Yes.
got an attorney, you go to bar search. You got a CPA, you go to the CPA statewide and check the person out. If you're
It-
dealing with a professional fiduciary, this is where you should go.
Now, can you see that?
Yes.
Okay. Yeah, so this is, you can see fiduciary.ca.gov. It gives a lot of information about fiduciaries, but if you want to look one up and make sure they are who they say they are, you can go to licensees and you go to license verification, and then you would search. Now,
You want
you
to put
have
in
to
your
find.
name or my name?
Yeah, let's do that. Let's find. So there's lots of different boards and bureaus under the Department of Consumer Affairs. So you'd have to find the right one, which is the professional fiduciary licenses. Now you can look them up by name or number. Should we just look you up by
Name,
name,
or you
Pete?
can 268, either way.
Looks like I've looked you up before. Okay. And so what you'd want to look for is, now the lower the license number, like anything, the longer they've been in the business. So Pete's got a low license number. He was one of the he cracked the top 300. Um, but the key thing, you want to make sure that they have an active license, that their status is active, because many are not active or not practicing still, but they still had a license issued when it expires. And then there's a little button here that says more detail. And this gives a little more detail as to the address, which probably should be updated because we've moved our thing. And then here's another one. It says public records. And this is an interesting one because it gives you um, the, I'd say the consumer, an idea of, has there been any disclosure events? Has there been any bankruptcies? Were they ever removed from a case for a certain cause? Were they ever, let's say, punished by the bureau for some act while they were fiduciaries? And they'll have links to all those records that you can find. Um, every year we have to report how many assets we have under fiduciary management, and this is a self-reporting thing, but you you have everything that is under our fiduciary management, let's say in trusts or estates, on that particular day, we have to report to the bureau. And it gives the consumer as well an idea of how active that fiduciary practice is. So if he says total client assets, if it's a very, very low number, like $10,000 or something, you would assume that that particular practice is not really active that much, despite what their license says. And then if it's super large, um, it may indicate that they're very busy.
Yeah,
Now,
one of the things is though, but the important thing is you have a place to complain to. So if you
yeah,
and to check somebody out to see if they're properly licensed. It's again, it's really, really important that but there is so much basic trust involved in what we're going to be talking about when we administer another person's estate. Let's get out of the professional fiduciary website. We're talking about fiduciary. You have to serve in their best interest. How do you charge, Eugene? I mean, Trevor?
I charge. So there's different fiduciary positions. Some are in capacity, like power of attorney for finances, uh, agent for advanced healthcare directive. Those I charge an hourly rate. My current hourly rate is 295 an hour. Every 3 years, and I just adjusted it this year, 2025. I adjust the rate to reflect the current market and so forth, and based on my experience and time. But but my rate's probably right in the middle, maybe a little higher than the average, but
Approximately how many professional fiduciaries are there in Orange County?
Actively, there are, I just checked this because I'm the chapter president, so I had to figure that out. Of our professional association here in Orange County, and there's Pete, there's 49 active licensees. There's about 60 Orange County fiduciaries that have been issued a license, but some of those are not active.
Okay.
Yeah.
So there's lots of choices as far as somebody for a private professional. Can anyone serve as a fiduciary in somebody's estate?
Yes. Um, if it's a one-off, of course. If there's family members serving, of course. Now, if you get to a certain amount and it's not family, then you have to be licensed. Now, there are some professions that are exempt from licensing. Those are attorneys, CPAs, even some financial advisors. Usually, the professions that already have a fiduciary standard of care towards their clients. However, that does not mean just because they're exempt from licensing that they know this stuff.
Yeah.
You know, it's a different field. So, but they don't have to
Yeah.
get a license
By the
to
way,
practice.
about 80%, maybe even higher. I'm not sure. I don't think there's any statistical data on this, but from just talking to people, most individuals name a family member.
Yeah,
But so they do this on a one-off basis.
yeah,
Today's session is not a scare session to get you to a professional. It's to sit down with your whoever you have named, and so that you can go through it with them and see whether or not they want to have the job. By the way, you should. I'm going to just. Do you sell anything? Insurance, mutual funds, etc.?
I wouldn't even know how to do that.
Well, then you should on your Ask First form
I
state
know
that fault.
I'm supposed to click false. I don't do that. But I honestly,
Yeah.
I don't do that.
Yeah. Okay. But you
It's
certified that the above is true and correct. By
yeah.
the way, if go to our website.
Oh, let me get there. Can you see that?
Yes.
Okay.
Okay. Just for full disclosure, I am a professional fiduciary licensed, and so is Eugene. That's the host. So all three of us are professional fiduciaries. We have formed together as a group, but we cannot be, you cannot name us as a business or as a group. You have to be named as an individual in your documents. So we think the value of having a group is that we can name each other in documents. What's some of the other benefits of being involved in a group, Trevor?
Yeah, that's a good question, Pete. Because if you are looking at other professional fiduciaries, there's a lot of them that have teamed up together, and they've teamed up. Some have different models. So some of them, where if a case comes in, they'll serve as co-trustee, for example, with three of the partners will serve on every single case as the trustee or whatever. Our group's a little different. I like to describe us more of a group of independent practices, and we don't share income or revenue from each other's cases so much, but unless we serve as co-trustee, and that doesn't happen very often. But the but the advantage though is that we all need a really good professional network because we can be very flexible as a professional fiduciary as opposed to, let's say, a trust company, which uses everything in house. So if I'm like, Pete, you have a lot of experience. I need a care manager in the Brea area. Do you know of anybody that you've used? Those sort of things are invaluable in our field. Um, Also, when people are drafting or restating or amending their estate plan, people often ask, what if something happens to you? What is the succession to you? And now, when we talk about succession in a trust, let's say, we don't just because someone works in my office, it does not mean that they're automatically going to be my successor. It has to be in the document. So we look at the trustee successor provisions and see who's next. What has the grantor put in there? But if we are part of the process of drafting because they're interviewing us and we're part, we can recommend that, look, if you've named me as your primary and you're concerned about successors, I recommend you look at other people in our group as your second in line, third in line, and at least you'll have peace of mind that you have someone local. We have similar networks. We more or less charge in the similar way, as far as our fee schedules.
You
So it's
have
just, I think,
continuity.
yeah, yeah, it just gives people peace of mind, and we're not just this lone wolf who, we're leaving everyone hanging if something happens to us.
Yeah. Very good explanation, Trevor. Let's go to the outline.
Okay.
By the way,
Oh,
whether you are a professional, whether you not have a trust company, whether you're a family member, whether you name us your CPA, all the rules are exactly the same.
yeah. And we're
So,
gonna we're gonna talk about that tonight or
yeah.
tonight. I always say that. I teach a night class on Tuesday night. So if you hear me say tonight, I mean today.
Okay.
But yeah, I mean, to your point, Pete, we all are governed by the probate codes. Now, it doesn't matter if we're professional, family member, or corporations, we all governed by that. Now, this is the last session of It's Your Estate. You've gone through hours and hours of talking about these particular documents and the fiduciary positions for those documents. But remember, it doesn't matter how well those documents are drafted. If you don't choose the right fiduciary, and I don't mean professional in that, I mean just the person,
And within your own family.
yeah, within your own family, then it doesn't matter how well or how much money you spent on that estate plan, it could go awry. And so who you choose is so important. So when we're talking about today, again, it's not a scare tactic. It's more to get you to understand when you're considering your family members, usually an adult child, that you understand the job that they're going to have.
Well, there's
And
two jobs. There's really two jobs. One is upon incapacity,
right,
and the other one is upon death. Upon death is the easiest.
that's easy. My favorite clients are my dead clients. Um, okay. I'm joking out there. No,
Well, but it's actually fairly true. It's
well, as
because
far as yeah, there's not as much drama. I mean, there is maybe with the beneficiaries, but with
yeah,
the actual client, it's a lot more. There's a lot more at stake, and
while you're alive.
while you're alive, yeah. But during the documents, this is just a slide that says the document and has the fiduciary position, and then who are you going to put? And then remember, if you procrastinate too long and you've wind up in a state of incapacity, you could find yourself in a conservatorship. That's at the bottom. And that's not somewhere we want to be.
No.
But there is a fiduciary position for that too.
Yeah,
Um,
and go back a second on the slide. The durable power of attorney and the living trust, those two things you deal with money. Would you name the same person in both of those positions?
yes, that would be very prudent planning to do that. But you don't have to. And if you go back and sometimes I see this happening where people are trying to save money and they have a power of attorney from a previous let's say, estate plan and they don't want to change it, but they've changed their trust. Now they have a different person that's on their assets in their own name versus the person that's in their trust. If it's all your financial world, I think it's just better to have one person in charge of everything.
Yeah, so your durable power of attorney, your executor, and your living trust should likely be the same individual. And remember, the will is an emergency document if you have a living trust.
Yeah.
So 90% of the time, we never use the will when somebody dies. But
Yeah.
on the living trust side, that's where it's really important to pick the person because incapacity due to a stroke or a
Mhm.
dementia means they're going to be taking care of you.
Yeah. I have a slide for that. So, as far as your trustee, remember, while you're alive and kicking, so 99.9% of the time that your revocable living trust is in place, you check all the boxes. Now, this could be with your spouse, but let's say you're single. You're the grantor, you created that trust. You benefit from all the assets that trust owns. You are the beneficiary of that trust, and you are managing those assets for your benefit as your own trustee. So you have, and that's really what, there's no different, that it's not an entity separate from yourself or revocable living trust. Every asset that trust owns uses your tax ID number, your social security number. So it's really not really separate from you, but it's there in case something happens and let's say you do live through a period of incapacity. Now, not everyone does. Some people go from alive and kicking straight to dead, but a lot of us live through a period of incapacity. And in that case, you're still the grantor. You created that trust. You still check that box, and you're still the beneficiary. At least that's what it should happen. Um, and if you choose the right person to step in as your successor trustee, they're going to now be the trustee managing those assets for your benefit. And Pete, there's sometimes if you choose the wrong person, that particular step can be complicated.
Yeah, we'll talk, I think we'll talk throughout, but when you look at your own family, please look at it objectively. Who can handle, has the maturity to handle the finances. Your trustee can determine where you live. I mean, do you
Yeah.
move into a board and care or not? Because everything involves around money. Oh, what if your bills don't get paid? Your required minimum distribution from your IRA is not going where it should. Your tax returns are not being filed. Who's going to take you and pay for taking you to medical appointments? How about your investments? Is there anything? Who's there to do that? Um, I, who's going to be the communicator? And by the way, we should put 3 stars behind communication
Hmm.
because everybody will want to know what's going on. And if you don't communicate
Yeah.
to the rest of the family, you have all sorts of issues.
And one of the things is choosing this particular person while you are alive and kicking and you have clarity and you can really get some good legal counsel and talk to family members and not do it you see a lot of estate plans being pushed through because there's a crisis. And that's not when you want to be making these decisions. You want to get this done ahead of time when everything is calm and we can make a good plan.
Yeah.
Again, and so my last thing, when you're dead, remember you're still the grantor. So that's, good news, right? Um, but the beneficiary pivots because now you have your revocable trust is now an irrevocable trust. And it has this, and we'll talk about this tonight, but it's separate and identified from you. And therefore it has a different beneficiary, whatever it says. So now the the beneficiaries or whatever it says in those dispositive provisions, that's who are the new beneficiaries. But up until then, you are
And in this particular time period, the the estate does not belong to the beneficiaries yet, and
no.
you're deceased, so it's almost like in a state of limbo. And
Yeah. Yeah.
and in order to pass that title, you have to do a bunch of stuff, which we'll get into. But this is a great slide
Yeah.
because as you're thinking about who to name in your family, this is check the boxes here.
Yeah.
Talk about time
Yeah.
availability.
Yeah. And keep in mind, we understand that not every single person is going to have one person that checks every single box. I mean, nobody's the perfect trustee, but these are some good qualities to have. So, time availability. What is their time? Now, your most successful child, that is the golden child that would probably do the best job if they had the time, may also be some high powered executive with three young children, uh, and they just in a robust family life and all this, and they may not have the time to help you during your incapacity or when you die deal with all the administration. So that's something that you need to think about when you name them.
Yeah, one of the things that we do, or we ask the attorney to do, or our clients to do, is to allow the successor trustee to name a successor. So, for example, if you do name that son who's a CEO or a daughter who's a medical doctor or whatever, and they don't have the time, well, maybe they can choose a trustee, but that has to be written into your document that your successor trustee can appoint a successor. Another thing
Yeah.
too is talk about desire.
Yeah, so a lot of time, and I'm sure this has happened to you in the past, Pete, where you're just named in the document
It
and no
just
one's
happened
even.
yesterday.
Okay. Well, yeah, it just happens where you're named, no one spoke to you, nobody, they just assume that you'll take it. Now, yeah, as a professional, that's not as bad as let's say if you're a family member who doesn't want to do it and now feels they have to out of guilt or indentured servitude or whatever. But you may want to talk to them prior to naming them to see if they have the appropriate desire.
Yeah.
Because you don't want someone to kind of just be like, well, okay, well, if you don't have anyone else. Um,
Proximity. What do you mean by proximity?
Proximity means, especially during incapacity, but also at death, being close to the person that's incapacitated, uh, and the property is a lot easier to serve in these fiduciary positions than if you are out of state or across the country or even upstate, a couple counties away. It's much easier to help somebody if you're proximate, and that just goes without saying. It's just an easy way to do it.
Organization.
Organized. You want someone that's organized because, again, when we, uh,
Everybody wants to know exactly what comes in and what goes out. So
yeah, yeah. I
finding
mean, I
somebody
mean,
who's somewhat anal is
Yeah,
a real plus.
you've got these probate codes that govern you, like the duty to account
Yeah.
and the duty to keep things separate and identified, between let's say, the person before they died and then after they died. And even keeping track of your time if you're going to, if they're going to compensate themselves. All of these things require some sort of organization and listen, if the trustee is organized, it'll be beneficial to the trust itself, to the trustee, and the
Yeah.
beneficiaries.
Delegation.
Delegation. This is really important. Remember, I like to say that the office of trustee of an irrevocable trust is you are like a CEO. you don't do everything, but it's your job to make sure everything gets done. And I've seen family member trustees, they think they're doing everyone a favor by doing things themselves that they're not experts in. Like filing tax returns or even managing money or being a property manager or things like that where they don't delegate it out to a professional property manager, for example, because they think they're going to save the estate some money.
Yeah, not a
But
good
that's
idea.
not a good idea. And when you're dealing with estates that are even between $500,000 and up, it's worth it's worth it.
Yeah.
Um,
Communication.
Communicative. This is really important. You remember, you are the person that's gonna, in this, you have a duty to inform all the beneficiaries what's happening. And so you want someone that, like, you want to make sure you have someone that is good at returning phone calls, getting back to people within an appropriate time period, because that really, if you don't, then that silence can really be a problem down the line.
Yeah. Pillow talk starts to happen.
Is that a
Yeah.
legal term?
Yes, it is. Very much so. You
Yeah, yeah,
know,
no, it's
your
true.
brother-in-law. I remember your brother-in-law at the last party, and he bought that new car. And isn't he the trustee of your dad's estate? You know, it's just if uh, people think the worst, and
Yeah, they do.
so
And it's the outlaws. I mean the in-laws that
yes,
that bring it up.
yeah.
But again,
You gotta have somebody. In other words, if somebody in your family is a bully, please don't name him as the trustee. And at the
yeah,
same time, don't name the wallflower either,
yeah.
because that's the worst.
That's my presence. That's kind of people, there's certain people that have a strong presence. Now, sometimes that strong presence, you're right, is too strong. It's a bully. It's like it's mom chose me, and therefore I'm in charge, and I'm not going to listen to anybody, and they're just going to do it their own way. That's not the great way to approach this. And then again, if they're a wallflower, you don't want them sitting there going, whatever you guys want, I'm fine. Just let me know. It's just you need some command there. People, beneficiaries, they want a course of action because
Yeah,
they don't know either what's
yeah.
supposed to happen.
And
So
that goes right to the upper to be transparent.
exactly.
There's no
Yeah.
secrets.
No secrets. And transparency can be in the form of communications. It can be in the form of accounting, like accounts, and making sure that there's no secrets there. You want someone that's transparent, not a BS artist in
Yeah.
this job.
Uh,
Um,
but most of the time that we don't need to be bonded. However, if we have a probate or a conservatorship, that may become necessary. But I
yeah,
think the bigger picture is please don't name somebody who has had a bankruptcy. Please don't name somebody who's an alcoholic. Just because they're the oldest son does not mean that they're the best person to be in your estate.
yeah.
Competency, what's the standard?
The standard is really a base. I mean, it's not super high. It kind of depends on what your profession is. So, but if you were, let's say, worst case scenario, you end up in front of a judge because your siblings are suing you for the trustee. Well, the judge is going to judge you as a normal, prudent person would have behaved in that exact situation.
Business type person.
Yeah, yeah. But if you're like, let's say you appoint a kindergarten teacher that's as your trustee, they're not going to expect the
I
kindergarten
was a
teacher.
former kindergarten teacher.
No, I know, but what I mean is they're not going to expect the kindergarten teacher to be a expert in accounting.
Yeah,
They're gonna, so if her books are a little messed up, they're not going to come down super hard on her. But if you have a CPA that's your trustee, the court will come down hard on them. And for professionals like us, we have a higher standard in all this because of our license.
Yeah.
But I don't know, maybe you can explain it better.
Yeah, no, I think to having a basic competency, and again, the person doesn't have to do everything themselves. They just
Yeah.
need to have the
Yeah.
ability to hire good people.
Even for record keeping, it's totally okay to hire a bookkeeper or someone
Yes.
to kind of help you out. It's just you don't have to do absolutely everything. And then we'll move on from the slide, but I want to make sure people understand too, though, the liability that you are taking on while serving in these fiduciary positions. You are personally liable for all actions taken or not taken during the administration. So this goes back to if you are serving as a co-trustee, let's say with somebody, you're personally liable for their actions too because you're occupying the office of trustee together. Um, so there,
Please don't do this to a friend. There's just too much liability involved to have a friend
yeah,
serve in
and
this.
it's a fiduciary liability, Pete. Which I mean, can you explain the difference between
Sure,
fiduciary liability and
fiduciary.
just normal liability?
Yeah, but if you have normal liability, somebody has to prove that what you did was negligent and then show what damages occur. Under fiduciary liability, all somebody has to do is accuse you of not serving in their best interest, and you have to the burden of proof is on you to show that what you did was in the best interest. And
Yeah,
it's not, you got three choices and you didn't choose the best alternative, you could be held liable. And that's the last thing you want to do. And usually it's a lot of emotions that get involved. How do we find somebody? Let's say we want to hire a professional here in Orange County. Where do we go to find someone?
um, you mean like a professional fiduciary?
Yeah, or the PFAC.
Yeah. Well,
You're
yeah,
the
there's a
president of the local chapter.
yeah, okay. Well, I didn't know you were giving me that on a silver platter. Yeah, so I mean, the if you we do have the Professional Fiduciary Association of California is a it's a pretty robust professional association that not every fiduciary belongs to, but many of us do. And you can go get a lot of
The
information.
website is what?
Uh, P,
PFAC.org.
yeah, it's pfac-something.org, but you can just Google it. It'll come up.
So it's called the Professional Fiduciary Association of Southern California
Of
or
California.
California.
Hmm.
Okay.
Yeah.
So
And
uh,
that's
uh,
a good way to kind of learn more about the field. Um, Again, you can
the
go to
other
the
recommended,
bureau.
yeah, the other recommended way is to talk to your estate planning attorney.
Yeah.
Ask them to recommend somebody to you. You
Yeah.
can
That's
check
how
with any of us, and we can. We're professional fiduciaries as well, so
yeah.
you've got a lot of people to choose from.
And there's different ones. I mean, I had a lady call me yesterday and she had a pretty complex special needs trust situation. And I gave her some names that of fiduciaries that I know are more focused in that area. But they're kind of that. I think you're right, Pete. It's good to really ask your legal counsel as to what if they have a list of names, because a lot of times they've worked with them before, so they have
Yeah,
some confidence.
because one of the questions online is that how do you evaluate a good professional fiduciary to be a trustee? And it's difficult. It's like hiring an attorney that you
Yeah,
don't have any experience with, or a
yeah,
medical doctor that you don't. You hopefully rely on referrals.
yeah.
That
You
way,
rely on referrals. You meet the person, and they should be meeting you without charging you. Um, and it
Yeah, if
again,
somebody meets with you and wants to charge, move on to the next person.
yeah,
There is absolutely no liability on the person to meet with you. Even if you name a person in your document, that
yeah,
does not mean that they have to serve. In
Yeah.
other words, trust companies are very, if you name
Notorious.
a trust company, for example, and they find out upon your death or upon your incapacity that you don't have sufficient assets, they will not serve. And there are some professional fiduciaries out there that are charging individuals even though they're not having to serve. And we think that's unethical. So,
Well,
but
it's
meet with,
stealing.
I would say meet with two or three
Yeah.
individuals at least.
And the thing is this, you it's all this whole relationship runs on trust. So if you can't find yourself the ability to trust that person, even off one or two meetings, then don't name that person.
Yeah. Yeah.
And that's
Go with
true
your
with your
gut.
family members too. I mean, it's not just professionals. I mean, you have to be able to trust anybody you put in a fiduciary position because it is a bit of a leap of faith. I mean,
Yeah.
you're
Let's say you are named in a trust, but you don't want to serve. How do you resign, Trevor?
well, if I'm named in a trust and I don't want to serve, I could decline to act and we would look and it would go to the next in line. If I started serving and let's say I don't want to do it anymore, and by the way, I've never done that, but if that was the case, then you can resign. Um, and then it would go to the next person.
Yeah.
But
You got
yeah.
to read the trust, though. The two most important parts in a trust is your trustee succession plan
Mhm.
and your distribution.
Yeah.
The rest of your trust is pretty much boilerplate. So read those two sections carefully because it's like the Bible. You've got to follow the directions in the trust. And if the directions are not there, then we go to the duties as stated in the probate code. So
Yeah.
let's go through some of those
Yeah.
duties.
And the probate code is super long and it applies to many, many, many things. These particular codes are extracted from it that really govern uh, us as
All
serving
trustees.
all trustees. But I want you to think of it in this case, it's kind of more at that irrevocable trust period and Pete mentioned it before, when you die and your trust goes from revocable to irrevocable.
Well, even on incapacity, it goes from revocable to irrevocable.
Right, yeah, it does. But when you step in as trustee, you own those assets in a fiduciary capacity, not in a personal capacity, in a fiduciary capacity. They don't belong to the deceased person anymore, and they don't belong to the beneficiaries yet until you distribute it to them. So there's that period of time. It can be as short as 4 months, but usually it's probably closer to 8, 9, sometimes even longer if there's a lot of complex issues where you have all these codes that govern you as that, because you have fiduciary ownership of that until that time of distribution. And so, and this applies to everybody, not just professionals. Any family member has these codes that govern them in that position. So
Can an heir be a a trustee as well and be in both positions? And what
as a
might
ben,
be the problems there?
yeah, so good point. So most of us, when we choose a family member, the family member is going to be a trustee, but he or she's also going to be a beneficiary, right? When the professionals like Pete and I, when we serve, I have yet to be a beneficiary of a trust that I serve in. So we don't have that conflict so much. But when you're wearing two hats, there's these codes are really important that you stay in your lane there because there's a lot of conflicts that could arise because you're the beneficiary, but you're also the trustee, which means you're in complete control and command. So we got to make sure that you have to put everybody else's interest
Interest first
before your own.
before
Now,
your own. And that's
no,
that number 3 point, duty of loyalty.
yeah,
You
to the
got, the
beneficiary.
typical example is a car.
Yeah.
Gosh, mom left me, as a trustee, and she just bought that new Mercedes, and I want it. And gosh, my two sisters, I don't know, they don't appreciate the value of the MB, the Mercedes Benz. Could I just go ahead and purchase that Mercedes Benz from the trust?
Surprisingly, a lot of people think you can just do that, and they'll say like, "Oh, I'll pay fair market value for it, but I'm gonna buy it." Well, if you don't offer it to them first, you're not putting your best or their best interest before your
First.
own.
Yes.
So
Yeah.
the proper way to do that is to offer it to them first. Chances are they probably don't
Yeah.
want it. And then, you can then make the deal with them.
Yeah. And it's no self-dealing.
Yeah,
You
no
know,
self-dealing. Self-dealing is really another like that would be examples of self-dealing are a trustee, a family member trustee who's also, let's say, a real estate agent. And now mom always wanted me to list and sell the property, but if you're the trustee, let's say you're getting compensated to be a trustee, and then you are the real estate agent getting the commission on the sale, that's a self-dealing.
yeah. Or let's say you have a buddy who's by the way, there are more real estate agents than there are houses in the United States. So real estate is usually your largest asset,
Yeah.
and there's a lots of issues there. So
Yeah. No, everybody has a real estate guy. Every time someone dies, they come out of
woodwork.
the neighbors come out and say, "Hey, I'm a broker. I talked to Mr. Smith and he wanted me to list and sell his house." I mean, it happens all the time.
Yeah.
And you just got to be
Trustee can't take a kickback from the real estate agent if you give him the listing.
no.
It's there's these duties are really important.
Yeah. So
Can beneficiaries, let's say, can beneficiaries fire the trustee?
Not without reason. The trustee would have to breach these duties, first of all, and usually breach them because of negligence, bad faith, or what's the other one? There's
Malice.
malice. Um, but keep in mind who hired the trustee to begin with. It wasn't the beneficiaries. It was the grantor, the people that created that trust. And if they've passed away, the beneficiaries can't just say, "Oh, well, we want someone else in place," because they don't have that power. Now, if you breach your duties towards them and you don't provide accountings, you don't return their calls, you've done a bunch of stuff that's wrong, they could um,
Remove you pretty easily.
remove you pretty easily. But
Yeah.
but if you're doing everything right, they don't have that power.
Yeah.
Um, so anyway, so these are a bunch of them. We'll go through some examples later that kind of touch on these.
Well,
Pete, is there any of them that you want to kind of?
Duty to enforce claims. A lot of family members, parents lend money to their children, whether to start school, for starting a business, or they're having a rough period. The question becomes, should that be repaid to the trust, or should it be forgiven at the time of death?
Yeah, and it's funny that you mentioned that because sometimes, if that person that you mentioned is also a beneficiary, and most likely they are, you kind of have these duties that are conflicting with each other because you have the duty to remain impartial, and a duty of loyalty to your beneficiaries, but then you have a duty to enforce the claim with one of the beneficiaries.
Yeah,
I think,
I see this a lot in son is taking care of dad or mom, living in the house, and then mom or dad dies, and the question becomes, hey, they wanted me to stay in the house as long as possible and till I find a new place. Well, the problem is that you, if you look at code 16007, you have a duty to control and preserve trust property to make productive. As a trustee, you don't have the power to give rental income away. So you need to charge rent to a family member, possibly. And so
Or
if you have more than one child, what we do is we ask permission of all the other kids, whether or not the one kid or adult child be allowed to live there. And it's
yeah.
because of the duty to make all assets productive.
Yeah. And so in that situation, we've often had to evict family members that are I mean, that are beneficiaries, because we can't have them sitting in a property that's not producing anything. And yeah, I mean, those things come up all the time. I mean,
These are
you
very
can't.
real.
Yeah, you can be proactive if you have that situation where you have a adult child living in your house, or maybe they moved in to be a caregiver for you. But you can put in your trust instructions too. Like I had this once where they gave the caregiving daughter a year, and that said, and it explicitly said in the trust that the trust would pay the expenses of that house for a year, and so until the daughter was able to get out. So
But it
there's
needs to be written in the
exactly,
trust.
it
You
has to
know,
be explicit in there. We
so
can't just make that up and assume that's what you would have wanted.
the most of your lawsuits in this particular area are filed under the probate code 16062.
Oh,
Trustees' duty to report information and account to beneficiaries. What
yeah.
is that all about?
Well, the duty to account is the most breach duty, I would say, because first of all, it's hard. I mean, most people, accounting does not come naturally. It's not like some of us are very anal about it, but many of us don't do our own accountings and things like that for ourselves. So to do it for someone else all of a sudden because you've been foisted into this trustee position can be tough. Now, usually a trust will say, there'll be somewhere in there that'll say that my trustee shall account to the beneficiaries at least annually, something like that. You have to understand what the trust says regarding your accounting. Now, can you account more frequently than that? Of course. That's not, that's might even be beneficial for you, but you have to be able to, and the accountings have to follow a certain statute. So you can't just print out bank statements and say, here's my accounting.
Well,
There's
but that's better than nothing.
better than nothing, true. But there's, if from a professional standpoint, for example, the accountings I provide have to follow the statute. And
Yeah.
then the final accounting, you may or may not, depending on how contentious the administration is, but you can get what's called a formal accounting, which is what the probate court.
Every beneficiary is entitled to know for every dime that is spent during the time from the date of your death until they get the money, and they're entitled to know all the income from the time of your death to the present time until they receive the monies. So accountings are just huge. Let's go to the next slide.
Okay, I'll go through some of these. We'll go through quick. I just want to get people the difference between an estate administration and a trust
A
administration.
probate administration versus the trust.
Yeah, so those of us that have a will-based plan that don't have a trust, or if you die intestate, and your estate's over a certain amount, you'll go through what's called, will probate your estate. And it's in regards to the job, it's not that much different. as far as, you still got to marshal the assets, you still got to sell, you still got to distribute, all these things. But the difference between the main difference, I think, is that the estate administration is under court supervision. And because it's under court supervisions, there's a series of hearings. And one of the reasons why it takes so long is our probate courts are so jam-packed that, the hearings get pushed out, every 3-4 months now, rather than a couple of weeks.
Yeah, it takes right now here in Orange County, we're looking at a couple of years.
Yeah.
It's before you get done. Uh,
Yeah.
whereas trust administration, by the way, how long does trust administration take?
Well, it's not immediate. It takes, I'd say a very rapid one would be about 6 months.
Yeah, that's fast.
That's fast. Yeah,
That's
because
fast. But
there's
normally it's about 9 to 12 months.
yeah, exactly. But it's done and it's administered privately, so there's no court supervision on the administration. It doesn't mean the probate codes don't govern you in that, mind you. It just means that we don't have a court supervising it. Um, and therefore the fees are less usually, and the time is a lot less. And there's not as much any court involvement perhaps.
Yeah.
Yeah, here's another slide on that. But you see, most of the things are the same. Now, another distinction between an estate administration and a trust administration is a trust administration can begin upon incapacity. Not that we're sitting there liquidating assets and selling things off and distributing, but we can step in during incapacity as a trustee. On an estate, it's always after death. A cannot be used during someone's lifetime.
And it takes 3 to 6 months even to get if you need a conservatorship.
Yeah,
These documents are so important on the financial end of it. Uh, it's all about having legal authority to act on behalf of another individual, whether it's medical or whether it's financial. And that's why these documents are procrastination is the number one reason why people don't have these documents.
yeah,
So please, we don't want to scare you, but at the same time, if you're single and nobody has the legal authority to help you.
true. So we do hear, trust administrations are administered outside of court, but it doesn't mean that you won't ever go to court, perhaps. Remember, it's still if there's any issues, litigation or anything with a trust administration, it will be handled in our probate court. Now, there's other times when a beneficiary or interested party can petition the court. So one of the first things you do from the office of trustee is there's a statutory notice, 120-day notice that basically it's just a one-page notice that gives information about, okay, this trust is now irrevocable. Here's the information for the office of trustee if you need to get a hold of them. And it's being administered, in Orange County or wherever it is. And oh, by the way, here's a warning that says you have 120 days to petition the court if you feel there's any, I don't know, undue influence.
You don't even have to petition the court. You could just say you object.
You can.
Yes. Just all you have to do is say you object to the trustee. And then the question, of course, is why are you objecting? Well,
Yeah.
if a beneficiary believes that there was fraud in the execution of that trust, or there was undue influence, or they believe that the trustee is just completely inappropriate, or for a variety of reasons, that 120-day period is there for the beneficiaries to protest one way or the other.
Yeah. And and this is getting a little in the weeds, but it doesn't always have to be the beneficiaries that get a notice. You could omit a child, let's say, but because they're an heir at law, they would still be entitled to this notice.
So immediate family members, individuals that are named in the document receive this 120-day
Yeah.
notice.
So
And by the way,
that 120 days then, I mean, I'm sure you're the same, Pete. Like a professional fiduciary, I know, and it'd probably be very good practice for a family member. You are not distributing anything during this period. That's so that do the math. That's at least 4 months you're putting on a trust administration just for the notice period to
and you
lapse.
want to have an attorney draft that notice. You do
Yeah, yeah.
not want to draft that notice yourself.
You don't want to draft it, but you want to understand what it is.
Yeah, because it has
And
to be a particular font size. It has to be done in a particular format in order to be legitimate. So if you are thinking that now you've got more than one child, adult child, please have them hire legal counsel in the event of your incapacity or death.
yeah.
Because this 120-day period notice has to be done.
Yeah. Now there may be other points of time when the trustee during an administration gets to a juncture where there's some disagreements or there's something. Let's say, for example, we're selling the family home and two people agree on the price and one person does not. The trustee can also petition the court for instructions on, how to get out of this instead of just pushing through something and that could perhaps end up in litigation. They can petition the court for certain things. Is that
Yes,
accurate, Pete?
yes, it is. Just so you know that um probate laws are controlled by states.
Hmm.
So the wonderful thing about a living trust is that if you have properties in other states, then you don't have to go through a formal probate in those states.
No,
So if you have a California trust, and let's say you move to Nevada and you suffer from some sort of incapacity or death, then the trust document follows California law, even though you are in Nevada. So, and but the Nevada courts understand that, and you do not need to change um, your document while you're in Nevada. It should be honored. But in the document itself, in the trust document, it has a line in there that what jurisdiction your trust is going to follow.
yeah, and in that trustee notification, it does too. It tells you
Yeah.
where the administration is, the
Appointment and
domicile.
powers. What does that mean?
Well, we're getting to the point now, like, okay, you're coming on as trustee and you got to start doing the work. So one of the first things that we do, and when we come on, someone dies and you get usually a family member or an attorney or someone will help you get access to the property. We need to locate some things. So if we haven't already, usually there's a trust binder or something we want to find that has like the original will, and other uh, we call wet signature estate planning documents. Most of the like living trusts and things that you can often get away with a copy. So if the
Yeah, please
original
don't.
is lost, but
Yeah,
but
please don't keep your documents in a safety deposit box or in a safe at home. This should
no,
be on a shelf somewhere, easy to find.
somewhere we can find them. If you're coming in for, let's say you're replacing an existing trustee, you'd also have to get, you would need their resignation forms and that's also
Just
important.
because you name somebody does not mean that they're going to serve.
Yeah, yeah. So they could decline to act, and then let's say you step in as the second in line. You would need the financial institutions and the escrow companies, all that will want to see that resignation. They won't just take your word for it. Death certificates, we have to order those. They usually take as quick as 2 weeks. Sometimes they'll take longer, but you really can't start anything. You can't marshal any assets. You can't really do anything without that death certificate. And Pete, who gets the death certificate? Is it the trustee?
Yes.
I thought I thought the agent for the healthcare had to get them.
No.
No?
No,
Okay.
you can either get them. You can get them right here in Orange County at the Orange County
Oh yeah, yeah. Sorry, I
Administrative
meant
Office.
I didn't phrase the question right. Who has to apply to get the death certificates?
Um,
Up,
the trustee or the agent for the healthcare or
yeah.
in
Like when
other words,
someone
who
dies,
has the
they
legal capacity
yeah.
to get a death certificate.
Okay.
A stranger can't go in and get a death certificate.
Right. So bonding if needed, most of us don't have that. EIN number, again, when your revocable trust becomes irrevocable, in in order to marshal the assets from the financial institutions, you're going to have to bring in a new EIN number of that now irrevocable trust. So that's something that your attorney can get for you. They can get it same day. They apply online with the IRS and they get a new EIN number. Um,
The important part about that is that in the year of your death, depending on your estate, how you have assets titled, it may require multiple tax returns.
right.
One for your estate, one for your trust. So
One
that's
for one
California,
for your personal,
and one for your
up
personal.
before you
So you
die.
could, yeah, you could have 6 tax returns in the year of your death or
Yeah.
incapacity. So again, you need a CPA involved.
Yeah.
And so again, whoever you hire or if you name one of your children, make sure that they understand they got to hire a CPA. CPAs today charge anywhere from $300 to $600 per hour. Attorneys, same thing, $300 $600 per hour. But they are needed uh, um, to do the administration.
Yeah. And then for an estate, for, let's say a court supervised estate administration, you can't really do anything until you get your letters. We call them your letters of administration. So that's at some point in the process, the executor will be appointed officially by the judge, and the letters will be generated, and then you can take them to the banks with the new EIN and do and marshal the assets.
Trevor, if I exclude one of my children from the trust, should I hire an attorney?
Yes. Yes. Yes, I would definitely do it properly.
Yeah,
I mean,
and
there's
if
so many things because not only just in the drafting side, but in the administration side, I mean, just the notice laws, right? If you mess up and don't give notice to the right person, it
this
goes,
is where this is where it really pays just to have one child.
yeah. Well, it goes from that 120 days to 3 years,
Yeah,
right? That they have the statute of limitations to come back and contest.
yeah,
So,
and and this is where the sometimes people get scared on this part. The thing of it is that no matter how poorly your documents are drafted, if a financial institution will accept them and your kids, if you have more than one child, work together, usually there's no problems. You get through. But if you have adult children who don't like each other, and there's somebody excluded, or you're giving a little bit more money to one child than another, or they just don't like each other, then it comes out after your death.
yeah,
So
it sure
you
does.
need help.
Yeah.
Um, when
Okay.
the deck is posted on, where do you find if I'm reading a question online. When
Okay.
the deck, when the when the check is posted on, where do I find it on your website? I'm not sure I understand the question, Elizabeth. Um, maybe, uh,
We can ask. We can have her ask at the
yeah, at
night
the end.
session. Okay.
Oh, the
So
PowerPoint deck. Oh, your outline is going to be posted right on our website, IYME.
yeah, yeah. I'm
And
gonna have as soon as I'm done. I'm gonna have Sylvia, who's our. Well, I'll copy. I'll send it to Sylvia and Fuad to
yeah,
get it up here.
and if anybody wants to directly from
Yeah.
Trevor, can email Trevor. What's your
True.
email address, Trevor?
Trevor at trustypro.com.
Okay. So he'll send it directly to you.
Yeah, yeah. I will get it to you either way. But this is it's a good outline because it just has a lot of check the boxes. You're not, again, not every bullet point's going to apply to everybody all the time. But so when someone dies, there's a lot of things we got to do. You may have to deal with funerals and burials and things. You got to notify people, family members especially, but even, friends. Um, Arrange for all the burial cremation. It may be prearranged. That's sometimes very helpful, but it doesn't always happen. Um, if there's pets, we got to deal with that somehow. That's another thing for you people drafting. If you have pets, it may be something that you at least make mention to as what you would want to happen, because otherwise it's up to us. um, uh, Meet with attorney. Uh, that's something that you'd want. That's one of the professionals you'd want in your, in your court there. Locate all the heirs at law for statutory notifications. Again, that's all the beneficiaries. Like Pete said, everybody's that's individually named in there, or any charities that are named in there, they all get notifications. But there's a there's an heir at law statute that it gets confusing because it kind of depends on who survives you. So if you have if you die, they first look to see, do you have a group of children? Do you have a cachet of children? That's your heir at law that are surviving. Okay, there's no children, then they look up at your parents. Are your parents still alive? No. Then, if you don't have children or parents, your next is your siblings. So that cohort of people may be your heirs at law. Now, if your siblings are not beneficiaries, they're still your heirs at law and they're entitled to the statutory notification. Again, if you don't have children or parents. So attorneys know this. Regular people don't really know this. So and again, the notice laws are statutes that we have to follow, and the consequences of not following them can be severe because like I mentioned before, the 120 days that they have to let's say contest the trust goes to 3 years. And that's a long time because usually by 3 years you've distributed the money and you don't have it anymore.
Yeah. One of the things the question I get a lot is what is the cost of administration? So the cost of administration upon someone's death, even if it's there's absolutely no issues, is probably right around 3 to 5% of your net worth. So gross estate.
Well,
Uh,
dying's not free?
it's not free.
Oh,
Uh, if you're married and there's a first death, then it's a lot less expensive. But the second death, it's usually 3 to 5%. What most families do is that they name one of their children, and then the that particular adult child hires legal counsel. Okay, that legal counsel will charge by the hour. So whatever their hourly rate is, that will that those are the charges. So if you hire a professional on the same time, we don't have to have as much legal counsel assistance because we have done this rodeo before. So
yeah.
whether you are hiring a professional or whether you are using one of your children, the
Yeah.
cost is going to be somewhat similar.
Yeah. And usually like I don't know how about you, Pete, but now like I'll usually hire an attorney for an administration, but I'll dictate what I want them to do. It's not like I go in and like, what do I do? It's like, okay, I need you to send out the notice. Here's the beneficiaries. I need you
Yeah.
to do a NOPA. I need you, whatever it is. Okay. There's also notices with the county assessor's office. If you have real property. There's the Department of Healthcare Services. If you're on Medi-Cal or something, you're supposed to send a notice. Social Security. A lot of times, the Social Security and the banks seem to. I don't know if you've noticed this, Pete, but they kind of talk to each other. So when one finds out that you've passed, the others find out. But you really pensions like CalSTRS and CalPERS. You need to tell them that someone's died, otherwise they'll keep paying the pension and then they'll claw it back once they find out.
So
So
what you're getting is that it's an administrative process.
yeah.
And when people pick their trustee or their fiduciary, they think of it as an honor or that it has to do with love. No, it's all about administration.
No, and if
Uh,
anything, if you want to give them a little project,
yeah,
it's like,
this is
yeah,
what we do. We
this is what we do. There's a lot of on the phone, on hold, sitting in banks.
What's the
But
first thing you do when you're notified that you're going to be a trustee, Trevor? And are you going to check to see whether or not that home is insured?
yeah, well, I mean, again, like we said, you are personally liable. So, I mean, there's all insurance is a, I almost worry about other people's insurance more than my own because I can control my own, but when I come onto a case, I don't know if the home has sufficient insurance. I don't know if the rental property has sufficient
Do
insurance.
you
I don't know if
do,
the autos.
do you
So
know
we
how
have,
many people have keys to the home?
yeah, yeah. Well, like that's another thing. Yeah, just uh preserving and protecting the home. Usually we'll change the locks. I inventory all the personal property as soon as possible just to have a baseline that I know that's there. Um, And but insurance, remember, you have home, you have home insurance, auto insurance, other things too, life insurance. But one of the things I want to point out and make mention to is when you have an insurance policy on a home, for example, there's a vacancy clause in there. Usually it says if the home is vacant for 3 months, then this policy is not valid because the policy is based on the fact that the home is occupied. And it may be less than a month, but you got to kind of know that. Often, as we said, these administrations can take 4 to 6 to 8 months. You probably will have a vacant house there for that long. So you really got to make sure that it's insured at all times. Um, Also, bank statements and investment brokerage statements, tax returns, previous tax returns. Those are all things that I would marshal going into a home to try and find out what they own and everything.
Make sure
Um,
you get a list of all the assets and how they're titled.
Yeah, but that list doesn't always just appear, unfortunately. You almost have to like do some investigation
Yes.
sometimes. And even have you ever had this, Pete, where you'll get a bank statement and it'll have the name of the trust, and then you go to the bank and they'll be like, well, no, they just put that name on the statement. They didn't actually put it in a trust.
Yeah. Or
Those
the
things,
reverse.
yeah, or reverse. It happens all the time.
Everything
Um,
is about title.
yeah.
So please, if you have a living trust, make sure you have all your assets titled in the name of the trust. By the way, we've got 10 minutes left.
Yeah, I'll
So
go
I
through.
don't want to I want to get to the important parts of the presentation.
Yeah, yeah, of course. Um, well, this is important. But just identifying promissory notes, rental agreements, We got to understand how the real property is titled, make sure the latest recorded deeds in the trust, if that's what's expected. And then any valuables and collectibles, we have to understand if they're there. Okay.
We
This is,
talked
this
about
is
the engagement of professionals.
so a trustee should have engaged a few professionals, perhaps an attorney for sure. It usually just a trust and estate attorney, but there may be situations where you need a business attorney or a real
And,
estate
and,
attorney.
and remember, the most conflicts are revolved about the real estate agent because the real estate agent's commissions are going to exceed almost everyone's fees.
Yeah, so if you own real estate in your trust, the people that are going to make the most money are not the attorney or the fiduciary. It's going to be the real
Real
estate.
estate agent. So
But
they don't know what they're doing a lot of times when it comes to estates.
yeah,
So
selling properties in estates or irrevocable trusts are way different than the other
yes,
types.
be
Um,
careful.
yeah, CPAs, remember we talked about all the times,
Yeah, make
all
sure
the
that they
tax
do
returns.
fiduciary tax returns.
Yeah, they got to understand step up in cost basis. They have to, there's forms, there's notices that we have to send the IRS that are telling them that this person now has a fiduciary relationship with the decedent and we're filing the taxes. Property managers, all that stuff. If you're on a if you have a trust that's ongoing and not just a distribution trust that has significant assets, you may have to hire a financial planner or investment advisor. There are rules in our probate code that govern how we invest in a fiduciary position. It's different than what there's more boundaries that we're allowed to do or not allowed to do, I should say, than if it was just your own money. So that's another thing. Insurance agents, we talked about that, and anything else. Notices, all kinds of notices. We talked about that. I'll skip over that. Um, Marshaling, inventory, and appraisal. You're going to have to get date of death valuations for all real estate and business interests. Uh, that data death value is really important to know. I mean, it tells you what your step up and cost basis is going to be, but it also can determine the fee basis for a professional, for example, that charges a management fee. There's lots of advantages to getting that knowledge ahead of time. You have to retitle all the assets into the now irrevocable trust, secure all real and personal property. We talked about that. Identify creditors and insurance company or any sort of, let's say, utilities. That if you have real property, you got to keep paying the bills and the property taxes and the insurance. So all those you got to have um, information on, and keep records of activities and expenses. And it's also good to document why you made certain decisions at any certain time. That is something that they tell us as professionals that is in best practices. But I also think as a family member trustee, it's also a good idea. Um, Fiduciary investing, sell property. Okay. Final distribution. Okay. Now, Pete, this is often it's not as it it often sounds like it's just a simple thing, just like here, distribute the money. But to get that final distribution, there's a lot of things that, let's say, an attorney will do. I mean, we need to get the accounting done, the final accounting. We need a proposed distribution schedule for all the beneficiaries. And usually there's some sorts of consents documents and things like that we are putting into for all the beneficiaries to sign, that they agree or at least consent to the final accounting, and they consent to the proposed distribution schedule and so forth. And they consent to the reserve that we're holding back. So that's something that we do at the end, and that can take some time. Final accounting and tax returns. Again, if you want in the year that you've made the final distributions, you want that year to be the final tax return. And the final tax return, I believe there's a 3-year there's 3-year statute of limitations with the IRS that they can come back and audit a return. So we usually will keep a small return. Well, I mean, a small reserve. It kind of depends on the situation, but for 3 years, and then distribute. Okay. How long is this all going to take? We talked about this earlier. Probates can take over 2 years now. Trusts can take 6 to 12 months is on average, but they can even take longer. How do we make this easier? Well, get your estate plan in place. Keep it updated. Keep it relevant and current. When appropriate, inform your representatives or the people in those fiduciary positions about your wishes, where your accounts are, where your documents are, the professionals you have in your life. That'll help your successor trustee. Prearranging funeral plans and just keeping things organized and emergency documents handy. Okay, I think that's it. The rest of them are just fiduciary slides that are at the end, but we can stop there.
That's good job there, Trevor.